jurors are not present. There were a couple of matters that came up that we were going to address that we haven't. One was a subpoena DT that was issued by the defense, and it came back with some material that was released to the defense. Part of that material was in a separate envelope, which was sealed, which says information was shared for our use only. Contents include a report on validation study, MVAC system recovery of DNA from evidential samples that have been redacted by San Bernardino County. The court could request the documents from San Bernardino County or open the documents that were shared under restricted use. And so I'm not really sure what that meant. But I reviewed the material inside of that envelope, and it is entitled Validation Study, MVAC System Recovery. And basically, it's just a description, evaluation of the MVAC process for recovering DNA, and compares it to using dry or wet swabs for recovery. So I don't see any reason why it shouldn't be released to the defense. Obviously, if the defense were to call any witnesses utilizing evidence obtained through that system, I think this report would be discoverable. But obviously, if you don't, then it's work on it. So I'll release that to the defense now. Secondly, we had a, was this ever marked? Please. No. Okay, so we had, the prosecution indicated that they had retained a forensic accountant to review Mr. Merritt's bank records or bank transactions. And instead of issuing a report, he provided a series of documents. The first one being 9 pages, basically listing each transaction with a date and amount. Then there's a second document that is 18 pages long that lists transactions in Mr. Merritt's Union Bank of California account. And again, it just lists all of the transactions, the date, the nature of the transaction, whether it's a deposit, a check, an ATM withdrawal, the amount, and where it was, who the payee of the check was, or where the ATM was. And then there's another 4-page document detailing the same activity for Bank of America transactions with it. And then there's a 1-page document, checks from Earth-inspired products that were cashed by Mr. Merritt. And it has the date, that it was cashed, and any memos associated with the check. And then there's a 10-page document that is cash transactions by category, transactions by various categories. And then there's a document, one-page document, Merrick's possible supply tool purchases as a percentage of his work receipts. And it shows various purchases from various vendors that could be considered materials for work. Doesn't list the amounts, but it lists, oh, I'm sorry, it does list amounts. So it has the total amount of all of those items, and then it shows what percentage of his total receipts from work that amounts to. And then there's a couple of graphs that graph all of that material. So the defense was requesting 402 hearing because they didn't have an actual report from the accountant, but I'm no financial wizard by any means, but it's pretty clear to me that this is basically his report, that he is detailing various deposits, sources of those deposits, various checks, cash transactions, other debits, sources of those, and listing them all just numerically in order, and then doing charts to categorize it into categories. So I think that basically is his report.
Well, the defense's problem is, Your Honor, is we retained a financial expert who reviewed all the documents. He wrote a 9-page report that detailed the documents he looked at and the conclusions he would make from those. Inside those, he did have some charts, and then he included 133 pages of documents of support that he references in his report to say, this is what I'm going to say, and this is how I'm going to get there. We don't know what their expert's actually going to say, or what opinion he's going to offer. And that's our problem. We have charts. Sure, I can read a chart and figure out what the numbers total, but it doesn't say what he's actually going to say they mean. And that's what I'm saying, we don't have discovery on what his actual testimony is going to be that we can present to our expert and say, this is what he's going to say that actually shows, and he can offer his advice on cross-examination. He can prepare a rebuttal report for that. Anything that we're actually entitled to, so we can know and prepare for this witness, so we don't have a trial by ambush that we begin from every expert they've been calling without a report, that we have to figure out what they're going to say while they're on the stand, turn around and talk to our expert while they're testifying, and figure out the direction we want to go for cross. That is not due process.
All right, well, as I say, I think these documents provide basis of what the expert is going to be testifying to. I don't think 402 hearing is necessary. If after the expert testifies on direct, you feel that you need some time to prepare for cross, I will consider that. Depending on whether or not, if the testimony is basically just following the information here, then I don't know that you would need much additional time. If there's other conclusions or opinions, then more time may be appropriate. So I'll return this document to the people. I don't know. Then we had, while a witness was on the stand, the people attempted to elicit from the witness some items that were on Mr. Merritt's phone. cell phone. They consisted of news clippings about the case, photos of the family, things of that nature. And the one item that the people that we had a discussion about whether or not it would be admissible is sometime after bodies were discovered, there apparently was one or two internet searches with regard to changing identity. There's no evidence that the defendant ever took any steps to attempt to change his identity or move, see where he was, or anything of that nature. So the court concluded at that point in time that the fact that there was an internet search related to change of identity. And the search was the title of the search was How to Change Identity, the Strange Story of the McStay Family. So I didn't view what was actually searched. I don't know if anyone even has that. But just the title of it might suggest that maybe the McStay family is the one who changed identities and disappeared.
And just so the court's aware, Summer McStay's changed her identity. Her birth name was Lisa Aranda. So she has actually changed her name to Summer, I forget the main name she had, Martel. And so that was not actually her birth name.
So Mr. Merritt was interested in researching that?
I don't know. And actually, Your Honor, those aren't searches on his phone. Those are pictures that were done on another item that uploaded into his phone.
Okay, so at any rate, what I was presented with while the witness was on the stand was we want to elicit the testimony that there was some type of search or a screenshot of something about changing identity. And given that there was no evidence that Mr. Merritt ever attempted to change his identity or conceal his whereabouts or move or leave the area, I excluded that basically under 352 and evidence for 352 and relevancy grounds. The people have now filed a motion for reconsideration and listed a number of items on the phone that they would want to elicit. Most of those, I still believe, are not particularly relevant, and certainly evidence code 352 would be, I believe, an undue consumption of time on a collateral matter that would not help to elicit or illuminate any issues in the case. There are three items, however, that in conjunction with each other, I think are at least potentially relevant. So let me go through those. One of them was on December the 10th of 2013, Mr. Merritt apparently had a screenshot of Joseph McStay's cell phone records. And it also included Joseph McStay's contact list. Also, there were a number of photographs that were either downloaded or screenshots of the memorial where the bodies were buried, one of which had Mr. Merritt standing by one of the crosses. Again, I don't really think that was particularly relevant. Those photographs included the general area and the tire tracks that led either to or from the graves. Those by themselves, the overall scene pictures, I don't think are particularly relevant. I don't think they lead to any particular inference or conclusion. However, one of the photographs, the screenshots, was a close-up of the photograph of the tire tracks. That, I think, is more significant. And there was also a search relating to U.S. borders. And then, of course, the changing identity. I think if you put those together, that someone is either downloading or getting screenshots of close-ups of tire tracks at the crime scene that lead to the graves. And they're doing research on U.S. or searches regarding change of identity. I think if you put all of that together, and there are inferences or arguments that can be made from that. Certainly there are contrary arguments and inferences that can be drawn, and certainly that will consume some amount of time. But in weighing that, I think the combination of those 3 or 4 significant relevance that outweighs the consumption of time that it would take to air those. And so I would allow the people to put on the evidence with regard to the close-up photos of the tire tracks, the references or inquiries about U.S. borders, the reference to changing identity, and the fact that there was a screenshot of Joseph McStay's cell phone records and contact list on Mr. Merritt's phone. The other materials, bloggers' theories about the case, just general pictures, the scene where the bodies were buried, the memorial, pictures of the family. I don't think those have particular relevance, and I would still exclude those under evidence code 352.
First, Your Honor, if the court's going to make a leap that such information can be argued as relevant, then the defense would renew its interest of bringing in Mr. Espiritu to talk about Mr. Kavanaugh being upset with him, saying, "You did me dirty in business deals, and I know how to make people disappear. If anything happens, they'll find your bones in the desert." And he says, "And you're doing me dirty in this business deal." And we will learn from Detective Hankey that Kavanaugh expressed to Detective Hankey that he felt he was done dirty by Joseph by hiding all the accounts in customs, and that those were all his business, these are his accounts, and they did that. So the same thing to where Mr. Kavanaugh is showing, I was done wrong by Joseph, and I know how to make people disappear in the desert, and he makes that threat to somebody else. And the court's excluded that. Then we should be able to bring that in to show there are threats that Kavanaugh made against other people that's consistent with what happened to the McStays under the same circumstances.
Well, number one, it's not the same standard for admissibility as to potential third-party culpability as it is with regard to the defendant. Secondly, we've had extensive discussions about that, and I've already ruled that under the circumstances that it's not relevant and excluded on both relevancy grounds and evidence code 352. And I explained the reason for that is those statements were allegedly made a short time after the bodies were actually discovered in the desert. So anyone who knew the McStays and knew that they had disappeared and knew that 3.5 years later their remains, limited skeletal remains, were found in the desert, could say, I know how to make people disappear. You bury them in the desert and they're either never found or only bones are found. Anyone who, even if they didn't know the McStays, who followed the case or read about it, would also be able to make that same comment. So those comments, I don't see any relevance to them.
Well, the problem with that analysis...
Well, we're not gonna re-argue that motion.
I know, but the issue that I have is that you're already letting in third-party culpability evidence. So once you do that, it all comes in if it's relevant.
No, that's not true.
Explanation, that doesn't end it. And the fact is, they're making this a financial crime saying he stole $20,000. Mr. Kavanaugh profited $250,000 after they disappeared.
And I indicated that the dealings between Kavanaugh and McStay and Earth-inspired products, I would allow you to go into that. Any monies that you allege that Mr. Kavanaugh took from the business or was paid from the business or the sale of the business, I already ruled that that is admissible. So,
but threats tied with not just any random person, but somebody who profited $250,000.
You've already argued that. I've already ruled on it. Your record is made.
On a collateral issue, Mr. McGee tipped his hand. Mr. Hankey is about to testify. He was the one that did interview Mr. Kavanaugh along with his partner at the time. Mr. Hankey is solely being offered for the processing of the QuickBooks account and the documentation that's contained therein. The people, given the statements by Mr. McGee this morning, are preemptively lodging an objection to the court and a motion to exclude any hearsay statements made by Mr. Kavanaugh to Mr. Hankey during any subsequent interview, as one being outside the scope and two being hearsay. And that any questions that go to that, absent an offer of proof as to how they get around the hearsay rule, the people would ask the court to be diligent in understanding that concept and the objection of the people.
And defense can easily do that. One, if Mr. Hankey's going to testify about the QuickBooks record, Detective Hankey discussed those QuickBooks records with Mr. Kavanaugh. And when the discussions happened with Mr. Kavanaugh describes the things that, how he feel about what he found. So it goes to state of mind. That is an exception to the hearsay. And then it also goes to the fact that when he says they were doing stuff behind my back, these are also his feelings or what his impulses were. He felt screwed over by Joseph. He claimed all those QuickBooks were actually his, and I'm sure Detective Hankey will talk about the only administrator that was on those accounts was Mr. McStay. And if they're going to call Detective Hankey just for the sole purpose to discuss those records, that's what we did yesterday with Mr. West. So are we just going to hear the same testimony, see the same exhibits again?
Well, if it's the same, obviously it would be cumulative. I mean, it sounds like that testimony from Detective Hankey with regard to Mr. Kavanaugh would be beyond the scope, so I would probably sustain objections on that grounds. Whether or not it would be admissible in your case in chief, particularly after Mr. Kavanaugh testifies, may be a different story. So obviously Detective Hankey will still be available. He would be subject to recall. You can call him in your case, particularly after Mr. Kavanaugh testifies. It might be more relevant on a number of bases at that point.
And I do think there are some issues that we would not even have to call Mr. Kavanaugh first, especially if we can establish either state of mind or statements against penal interest. We're not obviously dealing with that today, but there are other ways that I think we can address that.
So let's just deal with what we're dealing with today. Anything else before we call our jurisdiction?
Well, and Mr. Moline asked a good question too. If some of the things that they're gonna bring in, I don't know what they're gonna bring in, Mr. Hankey, or Detective Hankey, is whether or not he took investigative steps, and if he learned information, how did he follow up on it? Because there was discussions with Mr. Kavanaugh about some of the transactions and some of the actions that were taken by Mr. Kavanaugh, and Mr. Kavanaugh explained what he did and why, and what rights he felt he had. Part of the question would be, Detective Hankey, did he follow up? Did he do anything with that? I know what the court's thought is on that as well. We just want to get
I gotta hear the direct first,
understood.
okay?
But that's just something else that would be of interest that the court should at least keep an ear out for on testimony on the record.
Sure.
Thank you.
Okay, I think you bring our